Well, good afternoon, everyone. My name is Nigel Gooding from the Data Privacy Advisory Service. We are a consultancy company which offers data services and also expertise on not only data and data privacy, but also the new General Data Protection Regulation. I think it's important before we start the presentation, which is primarily aimed at our recruitment agency colleagues here, just to run through some context about the General Data Protection Regulation. The General Data Protection Regulation is an EU regulation. It's not a directive, so the regulation means that it can be enshrined into UK law as it stands. It was signed about 18 months ago. The rules are with regulations that years implement within a European Union country, and it, in essence, looks at enhancing the current Data Protection Act, which was last signed in 1998, into something called a new Data Protection Bill, which will become the new Data Protection Act going through Parliament at the moment. The key reason for a new Data Protection Act and enshrining the General Data Protection Regulation into that Act is two or threefold. One of which we'll all appreciate how the landscape has changed, particularly in recruitment. Now, I remember a colleague of mine telling me, an old colleague of mine telling me that 25 years ago when he was working in recruitment, that someone asked him for a CV, and his exact words were, "I'm sorry, the secretary's on holiday this week, and therefore we can't actually send CVs across." And when they did send CVs across, they actually sent them through by fax machine or by verbal discussion about the candidate, and at some post someone would get a CV. But that's changed. Life's changed. People can look at a job board. People can apply online. People can change their wishes and expectations about job searches. In an instant, transfer millions of megabits of data across the internet within seconds across international boundaries. And so therefore, the General Data Protection Regulation is an attempt to do two things, one of which recognise the changing landscape of data and how we keep it. Perhaps we don't keep it in big filing cabinets or iron mounted stores. We keep it on databases, data sticks. We keep it in computers. We keep it on servers. But also, it's an enhancement to the data subject. Now, throughout this discussion this afternoon, we'll be focusing on something called a data subject. But if you're an employee, if you're a contractor, or if you're a member of the public, or if you're a customer, you will be deemed to be a data subject. So look at this in the context of both data subject as being an employee and a customer. So there is an expectation that organisations are already compliant with the Data Protection Act. And so when you look at the General Data Protection Regulations, there's a lot of enthusiasm around there's lots to do. Well, in essence, if you're compliant to the Data Protection Act currently, if you're doing the right things in terms of data privacy, if you know where all your data is held and you know the legal basis holding that data, you'll be fine. There's no real problem and nothing really to worry about in terms of moving towards the compliance the Data Protection Act will require, circa DPA, circa General Data Protection Regulation. It's the same thing going forward. The General Data Protection Regulation puts in new framework in terms of not only things that it requires you to do, but also a new accountability clause. So the key thing really within the General Data Protection Regulation is at the highest possible level of your organisation, just the same as a health and safety management system would be. It's really about getting board level accountability for data privacy. As someone said the other day, data is the new oil. A lot of organisations just function solely on personal data. A lot of organisations function solely on the basis of transferring information by computer. Yes, it might be the new oil, but if it leaks, it can be toxic. If it leaks, it can be damaging to the environment. So data is no different than oil in that respect. It has to be looked after and it has to be shared sensibly. So the accountability clause is the key thing, and it's important about awareness. So not only for recruitment companies, for those administrators and consultants who are dealing with personal information on a daily basis, but also the board members who are acutely aware that it's their responsibility and it's their requirement to keep data safe and ensure that data subjects' rights are maintained throughout the whole process. There is a change in the legislation. Primarily, it's about keeping an audit trail. All of you keep audit trails at the moment in terms of ensuring that people's rights to work in the EU, passport details, address details, verification through references, etc. You have to keep all those because of regulatory and legal reasons. And once again, the General Data Protection Regulation says that after it comes into law on the 25th of May next year, you will have to ensure that you keep records to ensure how you process data, how you process it fairly, and how you safeguard the rights of the data subject. The current data protection bill going through Parliament differs slightly from the General Data Protection Regulation because it enhances the current requirement for a data protection officer. A data protection officer is not the data controller. That's someone different. Data controller is someone who manages the personal information on a day-to-day basis and manages the processing. Could be an ops manager, could be a branch manager, could be a senior consultant, etc. However, a data protection officer is someone at a senior level who gives assurance, who gives safeguards, who is responsible for ensuring that the Data Protection Act, GDPR, is actually enforced and people are keeping data subjects' rights upheld, as you would expect under the Data Protection Regulation. Really, it's a senior level person responsible for data privacy, like you would have a senior level person in your organization responsible for compliance, responsible for risk management, responsible for finance, and responsible for health and safety. The General Data Protection Regulation puts in place some pretty secure requirements in terms of penalties. Now, penalties are both for breaches of not only data breaches, so therefore you lose data breaches, you lose information, you share information inappropriately, someone is able to look at it over your shoulder whilst you're processing it on a train. You've got an availability issue in terms of if you're in a bank, for example, and you're unable to access your account for 7 days, that's deemed as a data breach. And also breaches on integrity as well in terms of it. So it's not just leaving a load of documents on a train. There are a whole swathe of regulations around what a data breach might be going forward. On a data breach, the minimum fine is in EU law, 20 million euros or 4% of gross annual turnover, not profit, gross annual turnover. So you can do the sums yourself. But for an administrative error, for example, administrative error might be that you don't meet the requirement to issue a subject access request notice within the 30 days and you haven't got a good enough reason. That's just a mere 2% or £10 million maximum fine. That's pretty large when you consider the current Information Commissioner, the regulator in the UK, has a maximum limit of £500,000 at the moment. However, not only according to the fines, you've got to look at the reputation management. For example, would you go with Experian or Equifax at the moment? We all know the problems that Equifax have had in terms of their issues around data security. So there's reputation management, but also there's the risk of compensation. There always, by the way, was the risk of compensation. Data subjects are entitled to compensation currently under the Data Protection Act. But going forward, there will be a culture which says, you haven't kept my data safe, so therefore I have a right to some compensation from that. So it's threefold, really. It's the reputation management, it's the cash and the criminality that arises from a data breach in terms of regulation. And that criminality can go to directors, managers, and members of staff and the way they treat data. But also there's the compensation culture that we currently live in. The Data Protection Act, as it will be, from the General Data Protection Regulations, puts into place a new system called Data Protection Impact Assessments. For those people most probably working in the public sector, you'd be aware of a data privacy impact assessment or a qualities impact assessment. It's where that you make a change significantly affecting personal information data that is collected, and that significant change will result in the way that you process personal information. So therefore, there's now a requirement for you as an organisation to be able to prove that you've been through a privacy assessment and you put in place a risk management strategy. Yeah, I don't want to. I think the purpose of this exercise today is not to scare people. I actually think that the implementation of the new regulations is a fairly straightforward process. It is a change management process, of which is a risk management process. You will look at the risk associated from the work that you do when inquiring about the data you hold, making it compliant towards GDPR, and it's putting in place a risk management strategy. But a data privacy impact assessment, a data protection impact assessment is something that you're going to have to build into your future way of working should you make, for example, buy new software, or should you want to change a process about how you onboard new candidates and clients, etc. So I said earlier about security breach notifications, and there isn't, by the way, a process, unless you're working in certain industries, requirement at the moment under the Data Protection Act to report security breach notifications. The security breach notifications are quite complex about what defines. There is a threshold of what defines a security breach notification, and it has a significant material effect on the data subject. So, for example, if you were to leave my birthday card on the train, I wouldn't be too worried about that, and I wouldn't be wishing for you to run off and report yourself to the Information Commissioner. However, if you were to lose 50,000 candidate records, names, addresses, bank accounts, next of kin, and special characteristic information, i.e. that pertaining about health or passport or religious background or quality, then that would be something more serious of which you might wish to consider reporting to the Information Commissioner security breach. So once again, a new requirement under the General Data Protection Regulation. The key issue really is about data protection. Finding in a culture in your organization whereby technology, every change that is made, every action that you go through, it is actually data protection is the front of it. An accountability clause coming into it and clear evidence of the processing that you undertake and recorded that should you, for example, have a knock on the door from the Information Commissioner or at some stage in the future have a claim for compensation from a data subject, that you're able to defend your position but also show compliance really to the regulation. The last point on this particular, or the last 3 points on this slide really is about the legal requirements for transparency and fair processing. And currently under the Data Protection Act, you have to tell your data subjects, you should be able to tell your data subjects what you're doing for information when you collect a candidate details, where it'll be stored, where you transfer it to, and where you hold it. That is enshrined further in the General Data Protection Regulation. So a clear processing, clear statement of what you're going to do with that information and how you're actually going to hold it. And we're going to come on to consent later, but tighter rules where consent is used for basis of processing. And I'm going to say now, right at the start of the presentation, that consent is most probably the last basis for should be using for personal information. And I'll explain that in more detail as we go through the presentation. I mentioned earlier about the 4 stages of compliance, and it's really, really key here to understand that if you're partly compliant to the Data Protection Act, this should be a fairly easy process. If you know exactly where your information is held and where it's transferred to, if it's held overseas, who can access it, what third parties you share with it, this should be an easy process. And the third point is, if you know the lawful basis for processing, this will be an easy process. I actually think for a lot of recruitment companies it will be, because a lot of recruitment companies keep their information in one place. Legitimate and lawful basis for processing it, because people are trying to enter into a contract for goods and services, or they want a job. Employment regulations, there are a number of exemptions under the GDPR regulations and the Data Protection Bill for employment, and employment agencies, and they don't change. So the current exemptions you've got, particularly around confidential referencing, is a good example. They don't change under the new General Data Protection Regulations. You can carry on as normal primarily on that. But the extra responsibility of having to show how you do that, the extra responsibility of having to tell your candidates when you collect the information about what you do with it and who you share with it and where it's stored, may be seen as onerous burden, but are new requirements under the General Data Protection Regulation. So the 4 stages of compliance. So one of the questions we were asked is what's the easy way to comply to the General Data Protection Regulation? Well, the first one is using the ICO 12 steps. So the Information Commissioner is the regulator in the UK at the moment, and they regulate the Data Protection Act, but also the Freedom of Information Act. And they will become the regulator responsible for regulating the new Data Protection Act, which enshrines the new General Data Protection Regulation. So the first stage of that is awareness, ensuring the key people are aware of General Data Protection Regulation, and that's at your board level. So there are 2 ways you can show compliance to that. One of which is to have a brief presentation at your board so that they're aware. 2, there is a process in place documented by the board that puts in place a project management of the change activity within your organization. And 3 really is an awareness across the organization, and that can be done through awareness training, and that can be done through advising your candidates and clients that you're moving towards GDPR compliance, and really becoming an organization which values the data that you hold about an individual, and really seeing GDPR really as an opportunity to give back control to those candidates, to those members of staff, of their data. It's not your data, it's their data, their personal information. So the ICO 1 step is really a straightforward step. And it's really one that you can move towards that stage of compliance very, very quickly, primarily through that big awareness stage at the board level. Stage 2 really is most probably, I think, the most important stages of the 12 steps. And the reason for that is that you'll see something in there called ICO 2. So that's the ICO step. So ICO's second step to the 12 steps of compliance. And it's called information you hold. Why is that important? Well, the ICO have made a really big point of, once you've done the awareness piece, your next big piece is to understand the information you hold. Hand on your heart, if you could sit down today and say, I know where we hold every single bit of personal information about our candidates. Actually, we have 50,000 CVs stored in Iron Mountain. I know that we have 50,000 names and addresses, personal information stored on a computer database at the moment, and I know where all that is. I know that we don't share any of that outside the European Union. I know it's not stored on a database sitting in Wyoming, a database or processed by an organization sitting in a country which is not deemed adequate under the regulations. The ICO 2 step is a really important step. It's about understanding the data you hold, what systems you use to keep it in, where it's kept, and who can process it, who can delete it. So it's about understanding which staff can change that information, what third parties you share that with. And also, it's really important to know that why you keep it and your basis for keeping it. You know, I was talking to a client the other day who tells me that they've got stuff going back to 1999 and they're a recruitment client. And I said, well, you know, I have to say, are most of those candidates still alive? Are they still looking for a job? And why are you keeping it? Because under the General Data Protection Regulations, you're only allowed to keep information beyond the legal basis of which you first collected it for, if you have another legal basis, and we'll go through the legal basis. So if, for an example, someone wanted to do 3 months contract work, they did 3 months contract work, and then they went off traveling, and they were no longer part of your agency, you would have to justify why you kept that candidate's details. Now, you have a legal and regulatory responsibility to keep their details because you have to ensure compliance to work, in this case, in the EU or the UK, so that's one of the lawful bases. And you'd most probably have to keep their records for 5 years, 6 years, primarily on the basis of tax. Why are you keeping their details? And that's a challenge you will have to, at some point in the future, make a business decision, not a GDPR decision, because GDPR just says you must have a lawful basis for processing once you've gone beyond that first contractual obligation for that. So that's a really big ask for the business units to think about, actually, what am I actually keeping this data for? So the big piece you need to start doing is that data analysis, setting up a data register. Why, who, where, who, when, and where it's processed. A really key bit for that. You'll see in this ICO 12 international, so ICO 12 relates to the 12 steps, and in fact it's the last step, but funny enough it's the second thing you need to be doing, primarily because the scope of the GDPR regulations are where an organisation sitting outside the European Union processes personal information data related to those data subjects who reside in the EU, then therefore they're in scope. Where you, as an organisation based in the European Union, transfer data outside of the European Union, then you have to justify the reasons why you should do that, and you have to go through a number of hurdles to enable that to happen. There are countries that are deemed adequate under the regulations that says you can transfer this information. Isle of Man, Guernsey, Jersey, Canada, Uruguay are some examples of that. Andorra is another one that comes to mind. But primarily it's about understanding where you transfer your data. And then in that second stage, I've actually put ICO 11, the data protection officer. You're required to have someone senior in your organization, or it can sit outside your organization. It can be contracted in primarily, who can give you that assurance, can give you that subject matter expertise. It's not about having someone senior who processes the data. This role is really one step above that role and provides assurance to your board. You can start doing that work now. You can appoint a data protection officer and a subject matter expert now, but that's a really important role that you need to start looking at now. As from the 25th of May, the data protection bill is quite clear. Unlike the GDPR that said something different, the data protection bill says all data controllers must appoint a data protection officer unless you're involved in the judiciary process. I'm guessing a lot of recruitment companies aren't. So once you understand what data you hold and where you hold it, ICO 6 is really the key basis, your next stage. And that's really about the lawful basis for processing. The lawful basis for processing really, and we'll come on to very shortly, but it's really about understanding. So remember what I said about when you hold a piece of data, the first question you should be asking your consultants, the first person you should be asking your HR team, the first person you should ask those people who you might want to download a CV off a web-based web board is, what is your legal basis for processing that personal information? And we'll come on to the 6 bases for processing that information, and you'll be able to see how that might fit in with your business. In stage 3 is also ICO 10, data privacy by design. Look, if you make a change to your software, you need to record somewhere that you have gone through a logical process, like most business cases that would do, that you've assessed the risk to data privacy by introducing a new software, a new business process. So that's really a key requirement you have to do. You know, we as a company have provided, and we're providing a data privacy by impact assessment, which will tick all those compliant boxes in terms of it. I wouldn't worry too much about that. It's about putting a process in place in your change management system that you've got in your companies to ensure compliance with that. So I wouldn't get too worked up about ICO 10. To me, that's a fairly straightforward process. It's a fairly transactional process every time you make a change post the 25th of May. And it's not retrospective, by the way. But however, if you are changing software, if you are changing systems, if you are changing processes, if you are changing training within your team, you might want to consider that changes that you make now will affect data subjects, will affect candidates, will affect employees of your own employees post the 25th of May, and you might want to think about that early. So that's why it's in stage 4. So once you understand your information you hold, your legal basis for processing, you can start thinking about the big load of products that you need to do post the 25th of May, and they include. Okay, so I'll just go one step back on the ICO 8 children. Please don't get worked up about that. The ICO children step was primarily introduced into the General Data Protection Regulation to deal with social media sharing platforms where information is shared across. and the age of consent for organizations is 13. That links nicely, doesn't it, to Snapchat and Facebook? And it's not relative, I don't think, to the vast majority of organizations I've worked with. I'm working with at the moment financial services, I'm working with recruitment companies, I'm working in healthcare, and it doesn't affect them at all because they've already got safeguards in place around getting a legal basis of processing consent with under 18. So if you don't do business with under 18s, you might want to consider it. If you do business, for example, with 16, 17 years around apprenticeships or around that sort of thing, then use your existing arrangements that you need to process that sort of data by consent. But ICO 8, the new arrangements about children, please don't get worked up about. They are solely focused on social media sharing platforms. Keep on doing the good things you're doing under the Data Protection Act. ICO 7 is about consent, and I'll briefly touch on it here. I'm going to come back to it on the next set of slides. Really is consent management is actually the whole way through the General Data Protection Regulation. If someone gives you consent to do something, then actually you can do things with their data. However, the key thing to remember is that you can only get consent once. You can only get consent or legal basis for processing for one thing. So the good way I think about this is if that someone signs up to your recruitment agency, you send them a CV, you send them an application form, they fill that in, they send that back, and you say, actually, I'd like to market you out to this client and this client only. Thank you very much. You've got consent for that. That's absolutely fine. However, in 3 months' time, you want to sell them let's say, for example, a special scheme that you've worked up with Exeter Chiefs, happens to be on my local rugby team here, but a special scheme. Therefore, you can't really go out to that candidate and market them something different related to the original reason they signed up for. They signed up to be marketed out to client X, but therefore you're trying to sell them or send them information about something completely different. You would therefore need a separate consent if you wish to do that. I'll come on to how you might want to do that when we talk about the legal basis for processing. ICO 3, and the steps don't follow a logical process, by the way, because you would expect to say you do these things in order, and therefore you'll actually achieve compliance. ICO 3 really is about communicating privacy information. So at the point of collection, so when you collect information, either on an application form, on a web portal, or through a CV, you have to clearly communicate to the individual where and how, why, who processes it, what third parties, the name of your data protection officer, the name of your data controller, and what you're going to do with that information. Now, I always say, remember the days when you would go into a hotel reception and you would see a big goldfish bowl there, and it would collect our business cards, win a bottle of champagne, or win 2 nights at the travel lodge in Croydon, and put your business card in. Well, we all know why they're collecting the business cards. They're not collecting us really to be fit in traffic and give us a free night at the travel lodge in Croydon. What they're doing is they're trying to market on a business-to-business basis with individuals that have put their business card in. And what you would expect now under GDPR at that goldfish bowl, you would expect to see a clear statement of what they're going to do with our business cards, what they're going to do with our personal information, and a clear opt-in whether we would like them to market to us other goods and services they might have. So a clear fundamental change in the information that needs to be given to individuals at the point of collection. This can normally be done on the bottom of an application form. This can normally be done through a website. But if you go into Google at the moment, they have a really good privacy notice. And one of the best ones is actually going to Fitbit. Fitbit have a fantastic privacy notice, but you can't write your privacy notice until you understand where your data is held and how it's held, who you transfer it to, and does it stay within the EU or not. So it's really the last stage of the process, but it's a product that you're going to have to do. And once again, we've written some fairly generic privacy notices. Once you've done your data information dive, you've set up your data registration, your register start in ICO 2, you can start writing your privacy notices and get them on the websites. And that's the sort of thing you can do now. You can start doing those now and making them compliant to GDPR. Security and data breaches. Now, one thing that security and data breaches does is that ICO 9 and the information is available. We've got some stuff that we can share with people if they're interested at some later date about how you might want to fill out your data register. But when you're doing your data register, you'll want to ask the questions, how do we keep our data safe? For those people who read, you may not have seen it in the BBC News because it's been a very busy news weekend, but someone lost, I think, 200 pages of data, personal information data, security arrangements at Heathrow, sat on a data stick. And it's how we process information, how we allow people to download information. It's how what security systems we've got, what cyber security we've got. What do we do with information in terms of, are we collecting just enough information to keep it safe? How do we store information? Do we get rid of data that we don't need to hold and information that we hold, which is life expired and we've got no legal basis for processing? So once again, in ICO 2, you will make those judgments. And really, an ICO 9 looks at security. So how are we keeping people safe? What training we've got in place? But also, if there is a data breach, how are we going to manage that? And that's a real reason for getting your DPO organization set up early, getting someone in who can support you with that. If there is a data breach, how are they going to manage your reputation management? How are they going to how are you as an organization going to manage, for an example, the advising of the clients or the candidates or the members of staff that have had their data compromised? How are you going to deal with that from a business continuity perspective? It's no different if you have a fire in your office. A data breach is exactly the same. And who's going to talk to the ICO about it? Because you can't just go and say, we've had a data breach, but we don't know much about it. You got to go armed with a sack full of information and reassurances, not only for the ICO, but also for those people who have been significantly affected. ICO 5 is interesting. It's called Subject Access Request. And this gets people really worked up about, well, actually, what are we going to do? Because people have a right to have all their data as the 25th of May, 2018. Well, actually, they've got the right now. If I were to write into your recruitment agency now and put a check for 10 quid and ask for all my data, you've got to supply it. You've got to supply it within 40 days, but not 30 days as the GDPR will change. So it's nothing new. So you might not have got this information. However, how you deal with a subject access request. I'll give you a good example. One of our recruitment companies we looked after, someone wrote in the other day and said, under the right to be forgotten, I wish to be forgotten, and I wish you to supply all the information you have. Well, there were two things about that. One of which, you can't be forgotten if you've still got a contract and you're still working for us. Thank you very much. And secondly, you've got all the information that you hold because it's in a web portal. So the subject access request is an interesting one. If the candidate or if the member of staff has everything available to them through a web portal, you don't have to give them information which is already in their domain. So for an example, pay slips, giving you all them, thank you very much. Information related to the jobs they may have worked or their contracts of employment are sitting on a web portal. Their CV is sitting on a web portal. It makes your life a lot easier. And of course, if you know where you hold all your information, ICO2, what information do you hold and what format, then that'll make it really easy. If all of a sudden you've got 58 boxes of stuff sitting unreferenced, unrecorded, unindexed in an Iron Mountain store for the last 10 years, and someone writes in, then you've got a hell of an arse to do it within 30 days. So you might want to think then, once you've done your data register, about how we're going to respond to subject access requests. And once again, what we've done is we've actually put a very good mock subject access request up as part of our roadmap to compliance, and said, could you answer this if someone wrote in now? And I suspect 99% companies do that. But the key with data subject access request is put the responsibility for keeping information accurate back in to the candidate or the member of staff through a web portal, but the accountability always relies with you. And lastly, individual rights. Now, a lot of nonsense has been talked about individual rights. The right to be forgotten. Yes, you have got the right to be forgotten, but if I've still got a contract with you, you're still in contract. I have a legal basis for holding your information because I have to hold it for HMRC purposes or to prove to regulators that you had the right to work in the EU or UK, to prove the fact is that you held certain disablement barring service certification and that sort of thing, to keep information important about medical records, then therefore providing you for a legal basis for holding, I'm not going to delete them, and I can't delete them because I have a legal obligation elsewhere. So there are a lot of what I call nonsense developed about them. You'll see one of them is called the right to object. Yes, you've only got the right to object depending on which legal basis of processing you use. So they're not as black and white as you would expect. They're not God-given rights in terms of that you have to act on all of them. There are exemptions all the way through, and certainly for employment and agencies, there are a number of exemptions that actually sit within that. So once again, individual rights is not as absolute as you would expect, and the ICO guidance is quite clear about where that might sit in terms of it. So those are the 4 stages of compliance. The awareness piece at the board level, start digging now about the information you hold and where you hold it, and a data register. Thirdly, on from that point is, once you've got that information, make an assessment of the legal basis for processing. If you haven't got the legal basis for processing, you need to start taking subject matter expert advice from a data privacy expert about, well, why are we holding this? And you need to be making decisions about what you need to be able to do with that. And then following that, you then need to start looking at consent. You need to looking at privacy notices. You need to look at how we will deal with a security breach. You need to start looking at how you'll deal with a subject access request, and you need to look at how to deal with individual rights. What I've said to people is that, look, if you're expecting a gold medal level compliance by the 25th of May, which has a single web portal of which everyone can see all their information, of which they can update and keep their information accurate, so therefore it's really easy. And when a subject access comes in, you can point people in the right direction, then you're not going to get that, because some of that technology might take a time. However, if you're going to put some workarounds to that system, you'll get that in place by the 25th of May. And it's really about starting that culture now, about starting that journey now, understanding what data you have and what you actually physically do with it, and your lawful basis for processing. And I want to get on to the lawful basis for processing, because that's really, really important. And it's really important to take away the mythology. So remember what I said, your journey starts on what information do we hold and what is our legal basis for processing. And notice I'm not starting at consent here. Someone has said we can process your information. I'm not starting at that. That's most probably the last place you should start. So the lawful basis for processing under GDPR gives you 6 reasons that you can process information lawfully. And the first one, related to your members of staff and related to all your candidates, will be the performance of a contract. And so if you look in our little box here, it says performance is necessary, the performance of a contract with the data subject, or to take steps, enter into a contract. So let's look at an insurance web engine such as Gdpr or Compare the Market, for an example. They're 2 good examples whereby they share a lot of data across different insurance companies. We share with them a lot of sensitive data. We put in our health data, we put in our car data, we put in our date of birth and this sort of thing. And then they share it with a lot of other people. Well, actually, they don't ask consent to share it with 400 insurance companies. But because we wish to enter into a contract and look for a quotation, therefore we're covered. So as far as I'm concerned, and as far as the law is concerned, the vast majority of people you employ as agency workers, members of staff, or wishing to find a job will be covered under the legal basis for processing, because under performance of contract. The second one really is that my contract has now ended. I'm a 3-month agency worker. I've now gone traveling to Thailand, and therefore I've asked you to delete my data. Yes, you might want to delete the performance review data, but legally you have to hold their HMRC data for tax purposes, pension purposes, maybe also the right to work data. So under regulations, so fulfillments of legal obligations, under regulation and legal requirement, you have to hold my data. Although the contract's ended, the secondary reason why you're keeping my data after the contract's ended is you have a legal basis of processing. You then need to make a decision after that period has ended, the legal responsibility, do you delete it or not? My advice to you, yes. Purpose of legitimate interest, a really tricky one in terms of it. However, for an example, if I register with your recruitment agency tomorrow as a on-spec you haven't applied for a job, but I'm a student. I wish to look for summer working, etc. And I've applied to work in a hotel. The job vacancy is now closed. That's now closed. However, in 2 weeks' time, one of your consultants then markets and sends an email back to me saying, Nigel, I've now got a job working in a beach cafe. Would you be interested in working in a beach cafe? That to me is legitimate interest. Because remember, the original reason they contacted you under the lawful basis for processing is they wanted the job in the hotel. So therefore, they wanted a good and service. They wanted a contract out of you, whether it's for value or not. They wanted a contract out of you in terms of it. But what you've gone back is asking them about a different job. And to me, that's legitimate interest because they're still registered with you, they're looking for a job, regardless of whether the job was the same one or a different one. As far as I'm concerned, the legitimate interest of the business recruitment agency is to find Nigel a job. So that's fine. However, if 3 months' time I went back to you and tried to sell you rugby tickets, that wouldn't be a legitimate interest because you're a recruitment consultancy and you're trying to sell them something different. So that's one of the legal bases of processing. So the vast majority of your stuff initially will be the contractual arrangements, and then when you've got candidates sitting in your database and then going forward for another jobs in 2-3 months' time, it'll be under the basis of legitimate interest. So you'll have that tick in the box. I wouldn't interest yourself in the interest of a public or an official authority. This is really a good example of that. Is we're driving along the A30. One of those naughty little speed vans collects us. They work on behalf of Devon and Cornwall Police. Devon and Cornwall Police then go to the DVLA and get my registration documents. They then send me a letter. I'm not driving the car. Mel, my assistant, is driving it, and therefore I have to disclose her information. So that's a good example whereby a public body will and have the right to process data. Not relevant. Not relevant as well. This one, the vital interest of the data subject. This is where I heard an accident. I'm unconscious, or I'm in a coma, and the paramedics share their services or share my personal information with the hospital staff at the A&E, 2 different organisations. And in the vital interest of the data subject, they're allowed to share the information. And the last one is freely given consent. So if you look at what I said earlier, the vast majority of people signing up to a job will be signing up to that basis that they give permission for you to market you out to other organizations because they're wishing to enter into a contract. Freely given consent is where someone is actually giving your consent to be marketed for the rugby ticket. So remember, Mel here has signed up for sent a CV across for the job at the hotel for the summer. She's a student, and you sent her details for the rugby tickets. That would be only legal if at the point of capture you ask Mel to say, and would you be interested in opting in to receiving information about other goods and services. Remember what I just said about the legitimate interest clause? As far as I'm concerned, you marketing out candidates to other clients necessarily wouldn't need consent because you'd be doing it under the legitimate interest. If you wanted to belt and bracelet interest, then get consent. The key thing about consent is wherever you record and use consent is record it and keep, for an example, when a candidate signs up on the web, it's got to be a positive tick in and make a record of when they did it. So those are the 6 bases for legal basis for processing. I think it's really straightforward for a recruitment company. Please don't be done by the smoke and mirrors out there in the moment. You've got lots of ways that you can actually trade in exactly the same way as you trade at the moment, but you just need to give thought to how are we going to do this legally going forward. A quick definition of what personal information is. Yes, it's a name, or it's the context of which you collect the data. So, for an example, I always use the example of my father's old car. His first car was 22PYD registration plate. If that's driving down the A30 and I'm standing on a bridge, that is not personal information. I was parked outside number 1 Red Hills Close. That was where I used to live. At 1 o'clock in the morning, and the car's parked outside on the drive. You can link the one Red Hills Close, you can link it with 22PYD, and it both becomes personal information, because you've got two bits of information. At some point, you can find who owns the house, so therefore you can find out who owns the car through public available information. So just think differently about public data, public available data, and what personal data is in terms of it. The vast majority of information you'll hold about your candidates and your employees will be actually personal data. Try to do is look at 4 areas here for you. Consent and processing. So it actually does changes. I think probably the most risky bit for me under the recruitment bit and consent and processing will be an email with an attached to a CV. Reason being that you can't prompt discussion at the front in terms of if someone was on a web board. Someone on a web board, they would have read a privacy notice, they would have most probably read a consent notice, but now someone's giving you the information. So for example, you might want to think differently about if they do email your CV, what do you do? Do you send them the privacy notice back, or do you record the fact that they've given your consent in terms of it? You can give consent verbally over the phone and say, Nigel, thanks very much. Now, if you'd like to send me a CV and you're happy for me to send this to company X, then you can record that consent, but somewhere in your book or in your system, you have to record that candidate's given consent. To me, that wouldn't be belt and braces. You would have to think differently about how you might want to record that in terms of it. So I think that there are some real key areas you might want to look at and say, look, are we running under a lawful basis here under contract, or are we running under consent? Whatever you do, you have to record it. Sharing in terms of it. So really it's about sharing the candidate data information. So I'm sitting next to Mel here now, and Mel runs Mel's agency. I'm Nigel Agencies. I've got Simon's CV, and I want to share it across agencies, or I want to share it across employers. The key thing is that the candidate needs to know and needs to be aware who I'm going to share it with, and they also need to understand that if I'm not going to share it, how long I'm going to keep it for. So that whole bit about the privacy notice stuff is really, really, really important in terms of it. And you need to think about that data sharing bit. If you've got consent, go, and good for you, crack on, go smash it. But if you haven't got consent, or you haven't got a lawful basis for processing in terms of the contract bit, and you haven't told the individual through a privacy notice who you're going to share it, you might want to think about how you're going to do that in the future. And the individual rights in terms of it, yeah, you know, there's a whole lot of stuff spoken about this, but request the right to be forgotten and deleted. They can do that now. However, if you've still got a contractual relationship, if you've still got to hold on to the information, if you've still got a legal basis for holding it, that's fine. If you've got 50,000 CVs in your database going back 10 years, I would question you have a lawful basis for processing most of that stuff. You might say, oh, I've got a legitimate interest, but yeah, 10 years, you know, the candidate might have passed away. Circumstances might have changed. They might not be living in the UK anymore, or the EU. They might not be in that skill set. So you really want to look at what data you hold, how you hold it, and what relevance there really is. I think I was talking to an agency the other day. I won't name them for obvious reasons, but they told me that just 5% of their came from that database they held. So you might want to think about how you might want to do that. You also have to be careful, by the way, of going back to your database and asking them to refresh their details. And the reason why you have to be careful of that is that Flybe and Honda did it recently, and it's quite well publicised, and you can go on the web and find out about that information. And they were fined, I think, 88,000, 11,000. One was more naughtier than the other. But what Flybe did was wrote to 3 million customers of theirs and said, would you like to refresh your data for GDPR? Thank you very much. Unfortunately, what they did is they contacted customers who had opted out of receiving emails. So therefore, in clear breach, they'd opted out of receiving emails, but they sent 3 million emails out. And by definition, there were a number of complaints made to the ICO that actually I'd opted out, but in email. And the only way Flybe could have done that was send 3 million letters out to individuals by post. So you think of the cost, you think of the risk associated with that, and you say, well, actually, is it worth keeping 50,000 CVs, 25,000 of which might not be valid? Is it worth the fact being actually we just delete them and put them beyond any use whatsoever? So And data security is the last one. Please don't think of data security as just cyber security. It's not. Please don't think of security being around leaving things in data sticks in an encrypted state. It's members of staff. It's the way they work. Every time we go on a train, we see people with an open laptop for £14 privacy shield. They can keep information. If I am working on a train and I'm sitting next to one of your consultants and I view a name and address of a candidate or an employee, or how much they earn, or a piece of sensitive data about the fact is that they might have had a criminal conviction 8 years ago, then that's a breach and I can report it. The culture that you work in as well, and the processes that you actually put in place. So it's really about reinvestigating the culture you have in your workplace and the information that you actually get. There's a lot of good information out there about how to keep your information safe, about how you don't necessarily, and password security and that sort of thing. It's really about compliance now, and we've got a staff awareness piece as well, which is really, really important as well. That you want to think about how you make your staff aware, not only of GDPR but good business practices around keeping data safe. And so just quickly going through what you'll be doing now. We'll be accountable. So take responsibility for your data cycle. Someone in your organization at the top needs to say, as I use it, I'm Spartacus. I'm in charge of keeping data safe. It's about reviewing your existing policies and procedures that you have in place, and ensuring that where, for example, that you've examined all your data, that you justify the use of obtaining data through consent. So if you're using consent as your lawful basis of processing, be absolutely sure that you use it for one purpose and one purpose only. Be transparent, open, really, with your data subjects, not only your staff, because it applies to your staff as well as your candidates and people applying for jobs. It's really important. Respect individual rights, and not only the right to be forgotten, but the right to be removed, for rectification, for deletion, the right to object to processing, and the right to portability. It won't affect, by the way, the recruitment industry, the right to portability. Please don't get too carried away with that one at the moment in terms of it. You will have to work with your suppliers and partners to see what you can do to make you compliant. I'm guessing, and I'm assuming, because I know the industry reasonably well, the recruitment industry, you might outsource some of your payroll. If you send personal information, such as bank account details, names and addresses, to payroll providers or to accountants, you therefore have to have new contractual arrangements between those third parties of which you share personal information. You need to assure yourself that those third parties, whether it be your accountant, your payroll provider, whether it be your software provider, whether it be your data warehouse, whether it be the person who supplies you the leads through perhaps marketing, you have to be assured that they are GDPR compliant. So you need to start thinking about the arrangements that you have between those third parties. And you need to put in place addendums to contracts you already have that ensure that data privacy is ahead of that. And that's something we can help you with in terms of standard terms and conditions and clauses as an addendums to contracts you might want to put in place. So those are the sort of things you should be doing now. It's a cycle of activity. It's a cycle of managing your business. It's a risk management strategy. It's by identifying what are the biggest risks for your data search. When you do your data register, what are the biggest risks to non-compliance by the 25th of May, and reputation management, and putting action in place now. This slide is really, really important because, yeah, GDPR and Data Protection Act is all about, actually, it's really about compliance first and foremost. It's about risk management. Yes, it's about enabling our organizations to act in the digital age because things have changed. It's all about that regulatory piece. But you know what? It's all about doing the right thing. It's all about ethical business, about keeping people's data safe. Data subjects are more aware than they've ever been about their rights. PPI proves that. If you've ever flown and had a 3-hour delay in the EU, that's proved that in terms of it, because you're right to compensation. So therefore, it is really, really important to give your edge, your competitive advantage, that you actually are able to prove to your candidates and staff that you keep their data safe. That is so important in terms of it. And the real understanding about you're giving control back to your data subjects. You have contracts in place with your third-party suppliers to ensure that actually It's really, really important that we keep data privacy safe between us, and we have a really good working arrangement. We have audit and assurance in place. We have compliance regimes to ensure that is actually really important. It understands where your data is. You now know where all your data is, and if you've got them on 120 databases. I know there are some organizations, because we're working with them at the moment, have all their information, structured data on 120 different databases. They have about 14 unstructured databases. That include bits of paper, that include notebooks, and that includes downloaded Excel spreadsheets, all those things. So for example, if someone downloads a CSV file or downloads an Excel spreadsheet from your main recruitment tool, therefore, that is all needs to be GDPR compliant. And you have to ask yourself the question, why? So it gives you a real importance in terms of not only your culture and the way you react, but also your digital governance. But at the end, it gives you better brand protection. And that's really, really important in this marketplace. And all I say to you is look at Experian versus Equifax at the moment. Which two would you really want to do your number crunching with? So we've got a couple of questions from recruiters now, and just we're keen to wind up the last couple of slides. So I'd be keen to understand, when using a job board, what are the rules about when we can download a CV? Look, what I'm going to caveat everything with, it depends. Part of the legislation is not formed, but it depends on what the context is. Data privacy and personal information is always about the context. Remember what I said about my dad's car? Driving down the M4 on his own, just 22PYD, the registration plate, is not personal information. Link it with a house, link it with a CCTV picture of my father. If he was still alive, then it would be personal information. So I'm keen to understand a job board. But the key thing about the job board is that you need to work with your job boards and to ensure that they have got the legal basis of processing at the front end when they've collected the information. They should be able to tell the data subject who they are potentially going to share it with. I would have expected to see a privacy notice at the front of job site, or indeed saying, actually, the following organizations can access the information. Are you happy with this process? So it may not be a consent piece, but it would most probably be in the privacy notice of the organization of which the individual signed up for. So in essence, it's not a job for you, it's a job for the job board. It's a job for the job board to assure itself that when it collects the data, that they are able to tell the data subject that they're going to share it with a numerous number of agencies. Now under the Data Protection Act, a statement such as, we're going to share this with numerous agencies, etc. You may be contacted, be aware, fine. In future, post the 25th of May, and most probably going to have to list all the agencies they share it with. So you want to most probably start looking at your job boards, asking them the question, how are you going to deal with the consent and the lawful basis for processing at the front end when you collect the CV? So there's no problem for you. The problem exists at the front end with the job board. So the blueprint, if you follow the ICO 12 steps, you can't go wrong. And so the simple bit for me would be, what do I need to do? Really simple language, Nigel. Identify what data you hold and set up a register by business process. Candidate logs on to a website, put CV up, and then you can identify, do we collect personal information? Yes. How is it safeguarded in terms of people, process, technology? Tick. Is it high risk at the moment? Is it GDPR compliant? Yes. What's our lawful basis of processing? Tick. That's your data register. Once you understand that data register, you can then say, okay, so we've got a lawful basis of processing. That's good. So therefore, we understand the data is kept in the UK. Therefore, we can put that on a privacy notice. Writing our privacy notice. We can ask people like Nigel to say, can we have one of your privacy notices so we can bespoke it? It's that sort of thing. We've got a problem with consent. Do we need to ask advice for that? Do we need to appoint a DPO? It's those sort of things. Follow the 12 steps. You can't go wrong. Right. GDPR and the Data Protection Act does not say how long you should keep information for. So all this nonsense about I've had 3 months, 6 months, 1 year, what I'm going to tell you now is GDPR says you should only keep information for as long as you have a legal basis, lawful basis for it. So when the candidate leaves, the only bits of information you should be keeping are those bits which are for a lawful or regulatory purpose. And I'm guessing there'll be HMRC, pension, passport details to prove they can work in the EU and in UK, that sort of stuff. So therefore, it's to you to make a business decision whether you think. But if you've got stolen stuff for 10 years and you get a knock on the door from the ICO, or you get a data breach, and therefore you're asked, well, why did you hold the information for 7 years? You'll be asked to justify your legal basis for processing. And remember what I said about the administrative fines? 2% of turnover up to £10 million. So when does this start? From the moment they sign? Yeah, that's a really good question. It's from the moment of which you collect the data. So where you collect the candidate personal information or the members of staff personal information. So it would start from the minute you collect the information. So if it's an online system, it would be online. It's the minute they send the CV with their name, address, and personal identifier information. What information should be able to provide the candidates that they send? Yeah, everything. So the legislation is quite clear. There are some exemptions for employment companies, and confidential references are one, and that's currently exempted under the Data Protection Act. So if, for example, I give a confidential reference again to Mel here, to you as an agency, I am not obliged to disclose that, but it's really important that data subjects are made aware of that. Subject access requests are really straightforward. You only have to give them information that they've not already got. So if they ask for, I also want 30 weeks worth of payroll stuff, you can say, actually, we've already provided that, so we're not obliged to provide that information, etc. But the key thing about GDPR is it allows you to go back to the data subject and say, what specifically you're after. You know, are you after interview notes and exam scripts and that sort of thing? Or are you after payroll details or pension details or that information? So you can actually go back to them. It allows you to go back where you think that the workload will be quite significant. But of course, if your data is all in one place and you know where it is, it won't be significant, will it? And that's why ICO2, what information you hold, is really, really important. Then it won't be onerous. You can go back to them and say, can you drill down a bit more so that we can understand the information that you're looking for. If you want an example of that, it is actually go on to South Yorkshire Police's website and look at their notification form that for DSARs. DSAR is data subject access request. Subject access request is currently known in the data protection Act. Are there other big things we aren't aware of in recruitment within GDPR? No, nothing at all. Look, the Data Protection Act gives you a number of exemptions to safeguards. They retain in GDPR. No, there's nothing significant which will change the way you operate, apart from the way that you gather and collect information and may wish to use it for a secondary purpose. But you just need to how you interact with the data subject, how you may wish to do that. How do I keep track what candidates my other co-workers called? Put in the database, I think. Yep. You're going to have to get better at e-records keeping. It's simple as that. You're going to have to be very aware that you might not be able to ring Mel if she hasn't consented, for example, to be contacted by phone. Whilst she might have consented for you as an opt-in, and it has to be an opt-in, by the way, not an opt-out. Whilst Mel might have consented for her to be contacted about other jobs, she may only been asked to be contacted by email because she doesn't want to be called during the day, because Nigel is a big, bad, gruff employer, might get very angry if she knows she's looking for another job. So it's really important. It's really important that happens. Yeah, you are. Remember what I said about it's the job board's responsibility to ensure that where they share data with a third party, i.e. you, because they are the data controller, you are the processor, where they share data with you, that they have done everything that is right at the front end. I just explained what the competitive advantage was: ethics, right thing to do, brand reputation, lots of competitive advantage. That's a cracking. That's probably the most challenging question I've had for a while, actually. The scope of the regulation is fairly clear for residents, data residents who are residing in the 28 countries in the EU and in the UK post-Brexit. It's also very clear for countries who do business. For example, if you're an organisation based in Singapore and you send personal information to London, you are GDPR. You need to be GDPR compliant. Australia the same. Anywhere coming into. But what about? My view would be, and I think you would just need to take a bit further legal advice of this. If they are deemed to be non-DOMs in terms of tax purposes, you could most probably say, and they are working in Dubai, for example, for 3 years, and they're non-DOM status. To me, I would double check, by the way, what I would view a non-DOM contractor working outside as not being in scope with GDPR. My view is that if it were Nigel working in Dubai for 3 months because he was working on a big construction project in Dubai, but he was still resident of the UK, still resident for tax purposes, still resident for residency purposes in the UK or Europe, then they would be in scope. Yeah, this is a good point. So a name and address, anything that is personal identifier about a personal individual, despite the fact it might be already in the public domain. So for example, you might want to ring me and share a candidate with me, despite the fact you've got my details off the website, or if indeed LinkedIn, and I'll come back to LinkedIn shortly. Technically, it is still public, it's still personal information. Now, I'm waiting for some information back, I queried this primarily with the Information Commissioner, that none of us would be able to do business with each individual if we weren't allowed to ring people up who would actually advertise and put it in the public domain. Because why wouldn't I want you to ring me as a business? I want I want you to buy my my DPO services and my SME services. Why wouldn't I want you to do that? But technically, it is still PI information. So we're still waiting to say, how's that going to work in practicality on a business-to-business basis. Just be careful, by the way, of harvesting details from LinkedIn. LinkedIn's terms and conditions are really, really clear that you shouldn't be harvesting conditions, harvesting contact information unless you have a clear understanding between the individual that they're happy for that to do so. So just be careful on that one. But as from business to business, I think I'm fair game, to be quite frank, with business to business. However, the Information Commissioner has said that it's personal information at the moment, so just be a bit careful at the moment. However, if anyone gives a consent for that to happen, or or you've got a legitimate interest on the lawful basis, crack on. Well, GDPR police, I was told the other day that you'd only find out if you were at a data breach. No, you won't. You'll get found out if a member of the public, a disgruntled employee, a disgruntled person who thought they were the best thing since sliced bread, but didn't get the job, didn't get the appropriate feedback, had a real hard go at you. You know, the way people work at the moment, there are a lot of people at the moment causing a lot of stuff about GDPR. And interesting that a lot of consultancies working in the landscape, someone reported a number of them to the Information Commissioner because they didn't feel they were registered with the Information Commissioner as data controllers a couple of weeks ago. So you'll find people very quick, post 25th of May, will be writing into you, trying to catch you out. That's how you get found out. That's how you'll get policed. Maybe by exception, but when you do something wrong, then you'll get found out, not just by the Information Commissioner, but the data subjects. Your competitors will find you out. The competitors will certainly be there to stitch you up. And it's business to business, I'm afraid to say, and it might sound somewhat, people might have ulterior motives, but they will. They'll be out there searching and ensuring that if they can get any competitive advantage, that will happen. So thanks very much. You've been listening to Nigel Gooding rattle on. I'm afraid I get a bit passionate about the subject, but really about just quickly about us, really Data Privacy Advisory Service. We're a UK-based company, and we offer services supporting organisation to GDPR and DPA compliance. We've got about 20 years experience from us. I've got an experience not only in financial services, but also in healthcare and public sector, also in utilities and British Gas. And I can boast of the fact that I most probably, apart from the Queen, kept the information of 600 elected MPs, including David Cameron, the Prime Minister, and the Cabinet, the Coalition Cabinet's personal details safe, whilst being the Operations Director at the Independent Parliamentary Standards Authority. So we've got a fairly good pragmatic background. I think our job really is offer independent advice not to scare people. I actually think that compliance is really straightforward. Once you've got that roadmap, not difficult. Once you understand where your data is held, once you understand what your legal basis of processing, and the products fall out the back, most of those products we can supply in terms of notice, which you can bespoke once you understand the information, under consent notices, standard data privacy impact assessments. Where we got all those are the sort of things that we can supply in terms of it. So so thanks very much, everyone, for your listening in. It was a fairly whistle-stop tour. 2 bits of advice I would give you is don't panic. So I sound like Dad's army here in terms of it. We're operating in a number of organisations, offering which is fairly SME subject matter, where people can email questions in and actually respond in to questions. We can respond back from the help desk if that's something that you want to do. You've got the numbers, you've got the stuff, and you can contact us from that. I've just got a couple of last questions which I think will be really interesting for you to listen to. And it's really, really important. So, so the question is, if a candidate requests to be removed from your system, another consultant finds that a candidate on a job board and contacts them, anything happen? Yeah, you're quite in breach actually, because you shouldn't be doing that. So a candidate has been asked to be requested from your system. You're actually in criminal breach there, because if you contact the candidate, because under the Data Protection Act, there's criminality on 2 things. One of which is if a candidate asks to be deleted and then you don't delete them, or you then contact them, therefore that is a clear breach, and that's a clear criminality element of it. Or if, for example, you put data on beyond control and you encrypt it and then go back and encrypt it in the future, that's also a criminal offence as well. So you would have to be very careful about going on back to a candidate that's asked to be deleted and going back. They've clearly expressed a wish that they don't want to do business with you, and to go back and then ring them up off another job board would put yourself at risk of not only non-compliance, but also criminality. And those are the only 2 bits of criminality, by the way, in the General Data Protection Regulations, apart from the ones that already exist about. For an example, recruitment's quite interesting, actually. A lot of recruitment consultants, I'm absolutely sure, don't understand that if they steal personal information relating to candidates and clients and then walk off to another consultancy, you're actually in breach of the Data Protection Act, and that's a criminal offence. So you have to be very careful around these areas of where you're asked to do something and you do something, you shouldn't do it. And so now that's a no-no. The last question is, what about trading outside the EU with candidates and clients in America? Do I need to be compliant with clients and candidates outside of the EU if I'm trading the EU? Okay, so America is not deemed to be an adequate country in terms of GDPR, i.e. one that we can just transfer data with. But the important thing is it is covered by something called the EU and USA Data Privacy Shield. So my advice is carry on as normal with the States. We've just signed that, and in essence, it allows us to transfer data to and from the USA without hindrance. They are not deemed, by the way, as the EU as having a significant safeguards. However, there is a, how can I describe it, a moratorium in place between the UK and USA to allow that to happen. And the final one is, do I need to be compliant with clients and candidates outside of the EU if I'm trading from the yes, yeah, they do. So if your main base is based in the European Union, in one of the 28 countries, then therefore, and you're doing business outside, you still have to be GDPR compliant. Thank you very much, everyone. If you need any more information, you can certainly contact us. The dataprivacyadvisory.com telephone numbers up above. Mel will be there to take your calls, and thank you very much.